Good afternoon, everybody. Thank you for joining us today for the second part of our DCR licensing webinar. My name is Michelle Garakian, and I am currently serving as the Acting Executive Director for the City of Los Angeles Department of Cannabis Regulation. Today, our staff welcomes all of you to part 2 of the DCR webinar. This is an extension and follow-up from our March 30th webinar, where AED Jason Killeen addressed recent amendments to our ordinance and the DCR's updated rules and regulations. Today, we will spend time going over key aspects of the licensing process, including, but not limited to, DCR's newly revised forms, workflows, and other important efficiencies that will make the licensing process easier for our constituency and our stakeholders. To the latter point, Jason will detail some of these efficiencies during the presentation. Today's announcements are a result of DCR listening to the feedback of our stakeholders and working doggedly to try and make this process less bureaucratic and more business-friendly. DCR is pivoting to be more customer service oriented while continuing to center social equity in everything that we do. I mentioned this during the last webinar, but as this year progresses, DCR will focus on striving to reach the following goals: updating our licensing processes based on the recently adopted ordinance and revised rules and regulations, which will be discussed at large today. Transitioning existing licensees into the environmental review process so the department may administer the annual licensure process later this year. Expediting review and issuance of temporary approval to eligible applicants. Making effective and frequent updates to the DCR licensing portal and our website. DCR will also host more events detailing additional information and will make more staff available to our stakeholders. In fact, in consideration of recent feedback, we're going to be kicking off a new monthly event on May 3rd, which will be a Q&A webinar lunch with Jason Killeen, our EAD over licensing. This is an hour-long Q&A virtual lunch hour with Jason, where he will be answering any of the questions that you sent to us in advance. DCR will be sending around a blast about this next week. Please save the date and keep a lookout in your email. Developing, and just to return to some of the key items that we hope to focus on this year, we hope to develop and open up the social equity applicant verification process, which is a prerequisite to phase 3 retail round 2 lottery. We aim to announce the opening of the verification process in early May and open the verification process in late May. Just to say that one more time, we aim to announce the opening of the verification process in early May and actually open the verification process in late May. Staying in theme with more events and more information, we'll be hosting a webinar in early May to guide prospective candidates through this process. Lastly, we hope to open up phase 3 retail round 2 lottery in late 2022 following a successful verification process. This webinar is streaming live on our website as we speak and will be recorded and available along with the slides and all of the information discussed therein on our website for future reference. Furthermore, earlier this afternoon, DCR issued a reminder email to our listserv where you can find access to various licensing updates on our website. Please look out for that in your inbox. We thank attendees for submitting their questions in advance for consideration immediately following the presentation. The department will spend time answering as many questions as we can. Just a disclaimer, the department will not answer any questions about individual applications or existing licenses. Please stick around until the end. I'm hearing rumors that Jason may stay on longer to address new questions that we receive. Before I pass it to Jason, I'd like to take a moment to thank the DCR staff for working tirelessly to ensure everything was ready and set for today's webinar. And now I'd like to pass it over to Jason Killeen, our Assistant Executive Director, who will discuss upcoming licensing changes. Thank you.
Good afternoon, everybody. Jason Killeen, Assistant Executive Director, also known as your clown car driver, who has successfully taken you over the cliff And now we are cruising down Licensing Boulevard. Please keep your hands, arms, and legs inside the vehicle at all times. I do want to let folks know that to date, DCR has issued over 290 retail storefront licenses and non-storefront delivery licenses to businesses. Of those numbers, 105 of those retail licenses, whether it's storefront or delivery, have been issued to social equity applicants. So over 1/3 of LA's retail market is social equity. So, we don't necessarily get the press that reflects the accurate numbers or a true representation of how much of our marketplace is reflected in social equity. But I do want to take a minute to say that a significant percentage of our marketplace is social equity, and our social equity market exceeds the cumulative total for all of the other major social equity markets in the state. We are almost single-handedly a larger social equity market within LA than the rest of the state combined. And with that, can we go to the next slide? I just wanted to talk about some of the common misconceptions. Folks have inaccurately stated that the application process has gotten more difficult and or challenging over time. A lot of folks are not looking back to the original ordinance in 2018. Under the original law, only phase 1 applicants were eligible to receive temporary approval. And our old executive director, Kat Packer, worked very hard to convince the mayor and city council to expand the temporary approval process to our phase 2 applicants so that they could continue to support the phase 1 licensees. When phase 3 was going to begin, our director had requested the city council consider expanding temporary approval to all applicants to give our phase 3 round 1 applicants as well as other phase 3 applicants the opportunity to pursue temporary approval. However, that recommendation was not adopted. It wasn't until Director Packer reintroduced that concept in early 2020, and then it was adopted into code. So under the original law, it would have taken folks 1.5 to 2 years to achieve licensure. Folks would have had to navigate it through the state's full annual application process and received a state annual license before they could have even had a local annual application deemed complete, which would be a prerequisite for community meetings. So through our former director's leadership, the laws were amended to make the process easier and make licensure achievable before an annual license. Between Director Packer and Director Garakian, a lot of our process has been streamlined. We've created dedicated forms to capture the required information in a consistent manner, which meets the requirements listed in the municipal code. Previously, the code just said you have to provide these things to the department, but it didn't describe the form or manner. So early on, there were a lot of inconsistencies in how that information was delivered to DCR, which caused processing delays. DCR has also reviewed its processes, and we've streamlined the document review, and we've intentionally removed document requirements that were not needed by 90% or more of applicants. The site plan review, the premises diagrams as part of the pre-app review, those have all been removed from the process, and the business premises diagram comes in as part of the temporary approval process. So we've intentionally tried to simplify the process so that the licensure process is broken down into smaller segments so that folks have peace of mind that they're eligible for further processing before they make important business decisions, as well as expend monies towards the different fees that are due through the licensure process. Overall, our current process is simpler, faster, less cumbersome, and less expensive than it was in 2018 or 2019. And that's all thanks to the leadership of our executive directors, as well as the leadership of the mayor and city council. Next slide, please. Now we're going to jump into some of the updated amendments. So the ordinance is intended to become effective tomorrow. It's already been approved by the city council. The mayor has already signed the ordinance and it was transmitted to the city clerk. So the city clerk was in the process of publishing the ordinance, and as soon as it's published, it will be effective. Under the updated ordinance, owner means a person with at least a 20% aggregate ownership stake or equity interest in the applicant or licensee. Aggregate means the total ownership interest held individually or through an entity. So for example, an individual that owns 50% of an entity that owns 50% of a cannabis business would have a 25% aggregate ownership interest in the cannabis business. Our definition intentionally includes the word aggregate and looks at how ownership stakes are aggregated through various entities to ensure that folks are not associated with more license types than they would lawfully be allowed to hold. Person includes any individual, firm, partnership, joint venture, association, corporation, limited liability company, estate, trust, business trust, receiver, syndicate, or any other group or combinations acting as a unit and in the plural as well as the singular. So a person can be a lot of things. And if the aggregate ownership stake of the person is 20% or more, they need to be disclosed to DCR as an owner. Next slide, please. This is an illustration of a proposed applicant licensee business structure organizational chart. This is also a part of the chart that is on the LIC 4008 form. On that form, the applicant or licensee discloses who the owners of the applicant or licensee are. The direct owners of the applicant or licensee are considered level 1 owners. They're the folks that directly own the applicant or licensee. And those entities may be owned by other entities or natural persons. To ensure that folks comply with the various laws associated with being an owner, whether it's licensing restrictions on the number of licenses somebody can have, or the types of information that would disqualify somebody from being an owner, we need folks to disclose owners all the way down the organizational structure. Moving forward, we are simplifying the signature requirements on the forms to make it clear that when information is shared with DCR, we are looking for either the level 1 owners or their authorized agent to sign the form, or we're looking for natural people to sign the form. For any of the attestations or things that are associated with an individual owner, whether it's a natural person or entity, those need to be signed by a representative of the entity or that natural person. Otherwise, signatures from the level 1 owners or the primary personnel, the president, the CEO, somebody else within the entity that's authorized to sign on behalf of the entity, may sign the forms on behalf of that entity. As is always the case, most of the forms only require a simple majority of level 1 owners or a simple majority of level 1 owners plus the social equity individual applicant owner. Next slide, please. Primary personnel includes natural persons with at least a 20% aggregate ownership stake in the applicant or licensee. So if a natural person is an owner, by definition, they are also a primary personnel. It also includes natural people who manage, direct, or control the operations of the applicant or licensee. If the applicant or licensee is owned in whole or in part by an entity, and the entity includes natural people who manage, direct, or control the operations of the applicant or licensee, those natural people are also primary personnel and must be disclosed to the department. As rules and regulations are revised or the municipal code is updated, DCR may determine in its sole discretion that additional people need to be disclosed as primary personnel. And of course, we'll communicate that out if we need additional information or additional disclosures at the time it becomes relevant. Next slide, please. I also want to bring up a form that's been available for a few months now, but has not been widely adopted. It's a voluntary form. It's our Authorized Agent Acknowledgement Form, which is the LIC 4009 form. This form allows the applicant or licensee to designate an individual to sign and submit forms and documents to DCR on behalf of the applicant or licensee. The form was created to make the signature process and the submission of forms easier for the applicant or licensee. This authorized agent is also allowed to submit certain modifications, submit renewals, submit amendment records on behalf of the licensee or applicant, and they're also able to communicate with DCR staff about that application or license. An authorized agent must be an individual, and they can a applicant or licensee can only have one authorized agent at a time, who is also a primary personnel of the applicant or licensee, which includes a single owner with a 20% or more aggregate equity stake in the applicant or licensee, the primary personnel of the applicant or licensee. If a business entity is an owner of the applicant or licensee, and they have primary personnel who direct, manage, or control the use of the license, that person could also be identified as a primary personnel and be an authorized agent. So the form allows the owners to identify somebody who will have the ability to sign on behalf of the owners. In order to execute the authorized agent form, we do require notarized signatures from a sufficient number of the level 1 owners to constitute 60% of the total ownership of the applicant or licensee. If an authorized agent acknowledgement form is being submitted for a social equity application or license, the qualifying social equity individual applicant must also sign the form, and their ownership interest will count towards the 60% total ownership requirement. Next slide, please. As just a reminder, we went over the business structure organizational chart before. Level 1 owners are the natural persons or entities that directly own the applicant or licensee. If a level 1 owner is an entity, the CEO, president, or equivalent executive position may sign on behalf of the entity. With the adoption of the updated ordinance and the revised rules and regulations, DCR has expanded the number of forms that an authorized agent may sign. So we did temporarily take down all of our forms, and the team has been working diligently to get updated forms loaded, and most of the forms are loaded on the website today and are available. We will be doing an additional Q&A webinar to go through the forms in more detail at a future date. Next slide, please. As I mentioned earlier, most of our forms require a simple majority. So we prepared a few examples, which are also examples that are listed on the form. So if the applicant is an entity that is owned by John Doe, and John owns 51%, and John is also a social equity individual applicant. ABC Corporation owns 29%, and XYZ Corporation owns 20%. John Doe represents a simple majority of the equity interest. To execute the authorized agent form, John Doe and the president of either ABC Corporation or XYZ Corporation may sign the authorized agent form along with John to execute it. For example, 2, we have Jane Doe, who owns 33%, and she'll own 33 1/3%, and she is a tier 2 social equity individual applicant. ABC Corporation owns 42%, and XYZ Corporation owns 25 or 24 2/3%. Jane Doe and the president of ABC Corporation may sign the form together. However, Jane Doe and XYZ Corporation would not have the requisite equity share to execute the authorized agent form and meet the 60% requirement. So if in this example, ABC Corporation and Jane Doe have to sign the form, whether or not XYZ Corporation signs the form. Next slide, please. One of the other forms that we commonly get questions about or pushback from different stakeholders is our removal of owners form, which is LIC 4005 mod. This form has to be notarized. We will not accept a non-notarized form. If the owner being removed is a natural person, that person must sign. If the owner is an entity, the CEO, president, or equivalent executive position may sign the form. When an owner is an entity, DCR will not require removal of owner forms from owners beneath the removed owner in the applicant or licensee's business organization chart. So for example, if the entity being removed is a level 1 owner, DCR is not going to require removal of owner forms for level 2 or level 3 owners associated with the level 1 owner. By removing that level 1 owner and getting the necessary signatures to remove that level 1 owner, all other owners below the level 1 owner are automatically removed. Next slide, please. As we've been discussing, the ordinance has amended the definition of owner and primary personnel. We now have standalone definitions that are not tethered to the state definitions. The ordinance did clarify when an application or modification request may be deemed abandoned. It's created a refiling process. It's established processing timelines that are now reflected both in the ordinance or the municipal code, as well as our rules and regulations. We've provided clarification on the successor in interest and surviving spouse provisions. The language was updated to ensure that a successor in interest or surviving spouse would have the ability to continue to qualify as a social equity applicant, individual applicant for the purposes of a social equity application. And we removed the time frame for when that would sunset. So if somebody maintained their equity share as a surviving spouse, they could maintain that equity share into perpetuity, and the licensee would be able to continue to be considered a social equity license, even if the successor themselves doesn't qualify as a social equity individual applicant. And then we've created a standalone social equity applicant entity verification process that can be initiated once the pre-application review record has been deemed eligible for further processing. This new record type will give folks the opportunity to vet an entity in advance of submitting a temporary approval application. Of course, sole proprietors who are themselves the applicant or licensee, it's very easy for them to demonstrate that they meet the provisions of LAMC 10420. Next slide, please. DCR has published the revised rules and regulations. They were posted to our website last night. These updated rules and regulations have aligned with the modifications to the municipal code, as well as reflect updates to our licensing process. Most of the rules and regulations have not been modified since the department was created, and a lot of them referred to, various rules that applicants had to comply with in as part of the application process. As I mentioned earlier, DCR had created standardized forms to capture those individual requirements to ensure that they were coming in a uniform manner, which makes the review of those requirements a lot easier and has streamlined our process. We've also added those list of required information and forms and documents for the different stages of the licensing process, specifically for the pre-application review, the temporary approval application, and then the modification request types. As the director mentioned, we're going to be hosting another Q&A virtual lunch hour to go through those documents and forms in further detail. And folks will have an opportunity to ask questions during the Q&A virtual lunch hour to kind of get clarification on the updates and the changes to the forms, as well as ask for additional information or seek guidance on whether or not information provided meets the department's requirements. We've also been working to reorganize various operational requirements and to clarify and consolidate those requirements. As I mentioned, there was a lack of clarity previously from different stakeholders about what the signature requirements or disclosure requirements are in the forms. So we've updated a lot of the instructions and provided examples to hopefully provide additional clarity. All of the amended definitions that are commonly used in the DCR forms have been updated on those forms to hopefully add clarity. And then the rules and regulations have also been updated to clarify our notice of violation procedures. Next slide, please. Now we're going to hop into our licensing process. With the ordinance amendments, DCR is going to be processing pre-application review records within 30 days of the date that pre-application review record is deemed filed. When somebody goes into the DCR licensing portal and creates a pre-application review record, uploads the required landowner attestation, and submits it to the department, it's considered submitted. The applicant will have access to an invoice. Typically, invoices are uploaded to an associated record within 10 or 15 minutes when it's applicant driven. And the applicant has 30 days to pay the invoice. Once the invoice has been paid, DCR will begin its review of the record. As part of the review, DCR is looking to make sure that the record is complete, which means that the information, forms, and documents that are required for that particular record process are complete and in the correct form and manner. If they are complete and in the correct form and manner, then the record would be deemed filed. If they're not complete or they're not in the correct form and manner, it's not deemed filed, and DCR will communicate deficiencies. Certain deficiencies for pre-application review records cannot be cured. If the pre-application review record was submitted for the wrong location, or the landowner attestation form that was uploaded was incorrect when the DCR analyst goes to review the record will be deemed ineligible. For folks that like to go in and verify that information was successfully submitted, what we've done is we've updated the DCR licensing portal to allow for records that have a status of waiting for payment, which is the default status when new records are submitted to the department and an invoice is outstanding, to upload additional documentation. So if a law firm, a consultant, an applicant uploads the wrong form, uploads an incomplete form, uploads a placeholder form, and they know that it's not correct, and they go in while the invoice is pending and they upload the correct form, the signed form, whatever the missing information is, before the DCR analyst begins their review, then they've cured the deficiency in advance, and the record may still be able to be deemed eligible for further processing. As I mentioned, modification or pre-application review records cannot be amended. Therefore, DCR does not accept modification requests for pre-application review records. Next slide, please. A determination of eligible for further processing is required before a temporary approval application can be submitted. Once the temporary approval application has been submitted, the applicant again is issued an invoice and they have 30 days to pay the invoice. And within 60 days, the payment of the application fees, DCR shall complete its initial review of the application record. And I stress its initial review. If all required information, forms, and documents are in the correct form and manner, and the record is complete, the record will receive a status of local compliance underway. That's the status everybody is kind of striving for. That status reflects a filed temporary approval application, and we will communicate such to the state licensing agency, which would allow the state to issue a provisional license and or annual license if the applicant or licensee meets the state's annual licensing requirements. If the application is incomplete, the record will receive a status of additional info needed. Processing of the application will be suspended until the application has been corrected. DCR will provide the applicant 30 days to pay applicable re-review fees, which are our a la carte fees, and submit the corrected information, documents, or forms. If the record is still incomplete after the second review, it may be deemed abandoned. However, the revised rules and regulations do create a pathway for DCR to conduct a third review prior to abandonment. If an applicant makes a good faith effort, they pay their fees, and they submit the requested forms within that 30-day period, and we do a re-review of those documents, forms, information, and there are still deficiencies, we will allow them to have one more opportunity to cure those deficiencies, subject to the submission of the missing information, documents, or forms, as well as the payment of any additional applicable fees. Next slide, please. Temporary approval application records with the status of local compliance underway may request an initial inspection. DCR is going to be required to schedule that initial inspection within 45 days. Typically, it takes us about 2 weeks to schedule an inspection. We do ask for folks to provide us with 3 potential inspection dates and times. And normally we're able to accommodate one of those dates and times. Very rarely, we will not have staff available to accommodate those dates, and we'll have to ask you again for some additional dates or times. The assigned licensing analyst is now going to begin conducting the equity share review for applicable records. Equity share review has been one of those areas where we as a department have had a bottleneck. Dr. Brown's social equity team has been the lead on the equity share review, and she has limited staffing. So based on those staffing limitations and all of the other work that her team is responsible for, it creates a capacity issue. So to address that capacity issue and hopefully address the bottleneck, the social equity team has been cross-training the licensing team on the equity share review. And the assigned analyst will conduct the equity share review, and the social equity team will be available to supervise that review and or provide insider guidance if the licensing analyst has questions. We've started rolling out that process earlier this month, and we do believe that we are working through that bottleneck of about 130 records. Hopefully, the cross-training of the licensing analyst will allow us to complete the review more expeditiously and move folks towards temporary approval. Of course, the additional 21 positions that were recently approved by the mayor and council, once allocated, will go a long ways toward addressing a lot more of our licensing bottlenecks and ensure that we are processing things within the mandated timeframes that were recently adopted. Within 15 days of completing the equity share review, if applicable, or passing an initial inspection, whichever occurs last, DCR will update the temporary approval application record to a status of temporarily approved and notify the applicant. Next slide, please. In terms of the environmental analysis, the pre-application review, which is really the proposed business premises location, where the commercial cannabis activity is going to happen, the review of whether or not that proposed business premises location complies with the land use ordinance, which is LAMC section 105, and the information submitted as part of the temporary approval application process make up the applicant's draft project description. DCR is using the Department of Cannabis Control, the state agency's project description form. So we've basically adopted their form as our own. If it's not already up on our website, you will see a version of the form on DCR letterhead with DCR footers that will be used for our environmental review process. Hopefully, by requiring the same type of information the state is requiring for their process and serving as the lead agency for the environmental review, this will make it easier for licensees to navigate through the state's annual application process. With the form being updated, we do plan to have a webinar specifically about the environmental analysis process and explain it in more detail. So I'll just briefly go over kind of what the next steps are. But we are going to be transitioning folks that are ready to move forward over the next several months through the environmental review process with the goal of issuing requests for bids. They're mini bids because we have an established bench of environmental consultants who will be doing this review. They will be positioned to begin the review of individual projects in late June or early July. And then they will complete their review on a rolling basis. And as those reviews are completed, DCR will do the analysis and make a determination. Some folks may qualify for a categorical exemption. We may need additional information for the applicant to determine whether or not there are any impacts that may have to be mitigated or the submission of a negative declaration. You know, we'll cross that bridge and talk about it in more detail over the next several weeks or months, but we are moving people into this process starting this month. Any business that has temporary approval is going to be eligible to go through the environmental analysis process. And they will be able to submit that final project description this month. Next slide, please. So as I mentioned, we already have an established bench of environmental consultants. We're using the Department of City Planning's bench. We're going through the statements of work, and we will be releasing many bids to those contractors to have them bid on different projects based on geographic areas within the city. We're going to begin collecting those final project descriptions that will be bid out in June, later this month. Those project descriptions will be bundled for environmental review based on geographic area, and they will be bid out in batches to those consultants. The consultants will have 4 to 6 weeks to respond to our request for bids. Based on those responses, the city will issue a notice to proceed to the successful bidder, and typically the NTP process takes about 2 to 4 weeks. And then of course the consultants will begin to analyze the final project descriptions, as well as if they have questions, reach out to the applicant to get clarification on their questions. We do anticipate having our licensees begin submitting information to us so that we can move this process forward later this month. We are already working with planning and their consultants so that they will be ready to start doing the analysis of those final project descriptions in late June or early July. Separate and apart from the formal environmental analysis process, applicant or businesses with temporary approval will see a letter posted to their record that can be used to satisfy the state's requirement to renew a provisional license after July 1st of 2022. As part of recent changes at the state level, the Department of Cannabis Control is going to require some type of environmental document from the local agency that states that the local agency is reviewing the project description and that CEQA compliance is underway. So all businesses with temporary approval will receive this letter before the end of this month. And for businesses that receive temporary approval after, beginning on May 1st or later, will be eligible to get the letter uploaded to their record when temporary approval is issued. Next slide, please. As I briefly stated earlier, the ordinance did amend the requirements for a successor. If an individual if a social equity individual applicant dies, the social equity applicant or licensee may continue to qualify under LAMC 10420 with the requisite equity shares so long as the surviving spouse or successor in interest of the deceased social equity individual applicant inherits or otherwise acquires all of the individual's ownership interest in the social equity applicant or licensee. So that was an important change because the old version of the law had sunset provisions that would have made the application or licensee no longer considered social equity, which could result in their inability to renew a license after that sunset date. Next slide, please. Application modifications are going to be one of those areas where stakeholders are probably going to see a lot of differences between the old process and the new process. Again, pre-application review records, pending temporary approval application records, the business premises listed cannot be amended. The pre-application review process is site specific and we're making eligibility findings based on that location. And a business is not eligible to relocate until a license is issued. That has not changed. However, what has changed is entity substitutions, 100% ownership changes, all other types of modification requests may be submitted within 60 days of the submission of a temporary approval application record. So if you go in and you create your temporary approval application record and you submit it today, you have 60 days to submit associated modification requests, which would change your initial filing. After the 60-day period closes, we are not going to accept modification requests until a license is issued. And this is because we're being held to the processing standard to ensure that we are navigating these temporary approval applications to a status of local compliance underway within 60 days of the date that TA record is deemed filed. And if folks continuously modify those records, it makes it impossible for us to actually process it to the necessary status to move it forward through the licensure process. Of course, any modification is still subject to the payment of additional fees. Invoices are available normally within 10 to 15 minutes of the modification request being submitted. Application processing is suspended during the modification process. So if you submit a modification request on day 59 of the 60 days we have to process it, we're going to pause it at day 59. We're going to consider your modification request. And once we've finished consideration of the modification request, the code allows for DCR to have another 60-day period to finish its review of the temporary approval application. The assumption there is you submitted the modification request to change core information that DCR has already reviewed as part of that temporary approval application. So it gives us the benefit of a full 60 days to complete a re-review of that temporary approval application record. Hopefully we won't need all 60 days. Next slide, please. Types of modifications that could be submitted during the 60-day window include legal name changes, fictitious business name, doing business as changes, entity substitutions, removal of commercial cannabis activities, business premises diagram changes, ownership structure changes, adding owners, removing owners, and withdrawing and or canceling different activities. A new temporary approval application record will continue to be issued for entity substitutions or 100% ownership changes. If 100% of the level 1 owners change, it is considered a 100% ownership change, regardless of whether or not other levels of owners will also be owners of the new owners being swapped in or the new entity. Again, all owners below the owner being removed are removed when that owner gets removed, regardless of whether or not they're going to be an owner on a new entity being swapped in, or they're going to replace that owner somewhere else in the business organization chart. If all level 1 owners get swapped out and removed at the same time, it will always be considered a 100% ownership change. The workaround for that is people may keep one of those level 1 owners as a 1% owner, transfer 99% of the rest of the equity to a new entity, a new natural person, so that one of the original owner stays on at a 1% rate. That person will no longer be considered an owner once the ownership change is processed. And then they will be able to then transfer that 1% equity back to the new entity or the new natural person at the level 1. And because they have a 1% stake in the applicant or licensee, by definition, they're not considered a capital O owner. So we won't need a removal of owner form from them. So that significantly streamlines that process. Next slide, please. This is going through the license modification types. Licensees may submit any of the modification types at any time that temporary approval applicants may submit. In addition to what temporary approval applicants may submit, they may also submit relocation requests. Certain types of licenses, of course, retail storefront and cultivation specifically, may only be relocated within the community plan area the license was issued for. DCR did propose an amendment to that. That amendment was not approved by the mayor and council. Therefore, retail storefront and cultivation are still geofenced based on the original community plan area. Next slide, please. Refiling is one of the processes that Director Packer fought long and hard for. Refiling will allow a temporary approval applicant whose application was deemed abandoned after January 1st of 2022 to refile a temporary approval application subject to specific requirements. The refiling has to be initiated through the DCR licensing portal within 1 calendar year of the date DCR notifies the applicant by email that the original temporary approval application was deemed abandoned. To refile, an applicant will submit a new pre-application review record through the DCR licensing portal. The licensing team is going through records, and we will be updating the final status on those closed records from abandoned to abandoned-refile. If the record status is changed to abandoned-refile, you will see under the action items on the DCR licensing portal, the ability to click on a link that will allow you to initiate the pre-application review record refile process. This process will be available at some point on Monday, and we will be updating records between now and Monday afternoon to make that functionality available for qualifying temporary approval records that were abandoned after January 1st of this year. If it was abandoned prior to January 1st of 2022, it is not eligible to refile. And that is clear in the code. If the new record is ineligible for further processing, applicants may continue to submit new pre-application review records until one of those pre-application review records is deemed eligible for further processing, as long as they are submitted within the original 1 calendar year time limitation. So if the record is abandoned and you refile your pre-application review record, and that record is ineligible for further processing, and there's still time on that 1 year left, you may refile a new pre-application review record. Next slide, please. Refile temporary approval applications are not subject to a finding of undue concentration. This is a critical point that Director Packer made sure was included in this ordinance amendment. It's critical because for 2 reasons. One, the applications subject to the phase 2 requirements are not subject to a finding of undue concentration. The second piece, of course, is last year, the municipal code was updated so that phase 3 retail round 1 applications that were deemed eligible for further processing after January 1st of 2021 shall not be included in the calculation of undue concentration. That amendment is critical because it allows the department to implement the refiling process without taking away capacity from phase 3 retail round 2. I just want to say that again. For phase 3 retail round 1 records and applications subject to those requirements, for the records deemed eligible for further processing after January 1st of 2021, they're not included in the calculation of undue concentration, and the refiled record is not subject to a finding of undue concentration. So if you are one of the 200 applicants and you have lost site control and you have been unable to find a compliant location, if your record is deemed abandoned, you will have up to 1 year to find a compliant location and submit a new pre-application review record. If that pre-application review record is deemed eligible for further processing, 1, your record is not subject to a finding of undue concentration, and 2, because your application is not included in the calculation of undue concentration, you do not take away an opportunity from a phase 3 retail round 2 applicant. So once we've done our analysis for what capacity is available prior to the lottery, folks that are identified and selected through the lottery will have an opportunity to file an application. Next slide, please. Limitations on refiling. A refiled record may not seek authorization to conduct any commercial cannabis activities not listed on the original temporary approval application or outside of the community plan area listed on the original application. Applications that were originally subject to a finding of public convenience or necessity must be refiled at the same proposed business premises. The PCN finding is site specific. Refiling cannot be used to circumvent the PCN process. A refiled temporary approval application, as I mentioned before, is not subject to a finding of undue concentration. So if you are authorized to be in a community plan area, a refiled application may also be filed in that community plan area. If a refiled temporary approval application is later deemed abandoned for any reason, it may not be refiled. So you get one opportunity to refile, and you need to see the refiled application through because you won't have a second chance. Next slide, please. Temporary approval applications that were abandoned for any reason prior to January 1st may not be refiled. Temporary approval applications previously denied by operational law, or deemed ineligible for further processing may not be refiled. Temporary approval applications and social equity temporary approval applications with more than one qualifying social equity individual applicant listed to meet the equity share requirements may only refile the application under the original entity. For social equity applications that have one qualifying social equity individual applicant needed to meet the equity share requirements on the original temporary approval application, which is everything that's currently in our queue, because the city council has not adopted a recommendation to allow multiple social equity individual applicants to aggregate their equity, may refile under a new entity. Under the code, the social equity individual applicant for all of our phase 3 retail round 1, our phase 3 delivery, our phase 3 manufacturing and distribution activities, that social equity individual applicant may not be removed from the application until a license is issued. Because they can't be removed, if they aren't on that application that application isn't eligible for further processing. It's not complete without them. It can't move forward. The social equity individual applicant is the key for all temporary approval applications that were submitted as part of phase 3. Without them, there is no path forward. Next slide, please. Now I'm going to very briefly jump into the eligibility verification that is going to open up by the end of next month. As the director mentioned, DCR plans to make an announcement in early May about when the social equity individual applicant eligibility verification process will reopen. The process will reopen in late May. We do not have a firm date of when it will reopen, but it will reopen by the end of May. I wanted to just briefly run through these timelines because reopening this verification process is a prerequisite to doing anything needed for the phase 3 retail round 2 lottery. When this process reopens, the process will be open for 60 days. If you are a social equity or you're a prospective social equity individual applicant who wants to participate in the phase 3 round 2 lottery, you will need to register during that 60-day window in order to participate in the lottery. You must get verified as part of that registration process to even register to participate in the lottery. If you are a prospective social equity individual applicant that did not get verified under the original criteria, and you would like to get verified so that you can submit a social equity application for non-storefront delivery, for manufacturing, for distribution, to participate in the learning management system and all of the great things that Dr. Brown's team is putting out, get verified during the 60-day window. The window will be open for 60 days, and when it is closed, it will not reopen for the rest of this calendar year. So if you plan on submitting an application in the next 6 to 12 months, that 60-day window is your one chance to get verified to submit an application with you listed as a social equity individual applicant. Once the verification process is opened and closed, DCR will have at least 90 days to process all of those eligibility verification requests. I don't know how many requests will be submitted. When we opened the process back in 2019, we received over 2,200 verification requests, and we reviewed every single one of those requests, and ultimately over 1,600 people were verified as social equity individual applicants. With this process, we may have hundreds, may have thousands of people seek to get verified. The code gives us at least 90 days to process all of those requests. If less than anticipated numbers of verification requests are submitted and we are able to complete our review and finish processing in less than 90 days, we can move forward to the next step then. If we are oversubscribed and we need additional time to process all of the eligibility requests that come in, the code gives us more than 90 days to do it. We have at least 90 days. So these timelines are all the cumulative timelines that are identified in the code. Once we get to processing, it may take less time, it may take more time. We won't know until that 60-day window closes. So for that reason, as the department moves forward in making announcements and talking about next steps, we're going to limit those types of announcements and dates to the step that is immediately before us and giving folks a ballpark for when they may anticipate the next step opening. And not until we complete step 1 will we tell you definitively when step 2 and step 3 may happen. The way it's articulated in the code the social equity individual applicant eligibility verification process will likely take 6 months. Between the announcement, between opening it for 60 days, between having 90 days to process all of those eligibility verification requests, that gets us to 6 months. Next slide, please. So in order to administer the phase 3 retail round 2 lottery, DCR has to do another 60-day eligibility verification window. We have to process everything that comes in. We then have to open up a registration process for the lottery for folks that meet the lottery requirements. And that process will be open for 30 days. Then we have to verify those registrations to ensure that people are qualified to participate in the lottery. And then we have to provide 15 days notice of when the lottery will happen. Next slide, please. In order to participate in the phase 3 retail round 2 lottery, the registrant must be a social equity individual applicant with a prior California cannabis arrest or conviction and meet one of the 2 criteria listed in LAMC section 10420B1 Roman numeral I. You have to be low income and have a cannabis arrest, or you have to have 10 years of cumulative residency in a disproportionately impacted area and have a qualifying California cannabis arrest or conviction. If you don't have a qualifying California cannabis arrest or conviction, you will not be able to participate in the phase 3 retail round 2 lottery. That is articulated in the municipal code. Social equity individual applicants will be disqualified from participating in the application lottery for any of the reasons listed under 10403A1 or for any of the circumstances listed in LAMC section 10403A2. Again, we are not close to starting the registration process, nor are we close to administering the lottery. So DCR will be providing additional webinars in the future as more details become available. Next slide, please. This is a quick table of what the timeline for a phase 3 retail round 2 lottery may look like. Again, we have to administer the verification process, which will take approximately 6 months. Once that process has been completed, we will be able to start moving forward for the round 2 lottery. Before registration for the lottery begins, there has to be a 45-day period where DCR is providing technical assistance. That doesn't change the overall timeline because we can provide technical assistance in parallel with the processing of the eligibility verifications. You know, the code says DCR will provide technical assistance to prospective, so people who haven't been verified yet, or verified, which means you've already been verified, social equity individual applicants. That technical assistance includes, but isn't limited to, access to one or more of the DCR resources that are out there, webinars, presentations, our learning management system. Those are all considered forms of technical assistance. Again, that technical assistance can run in parallel with the processing of our eligibility verification request. The phase 3 retail round 2 lottery registration will be open for a period of 30 days. Again, we don't know when that will open. We'll post notice of when the lottery will occur 15 days prior to the lottery, and the lottery is anticipated to take 1 day. For social equity individual applicants selected through the lottery, they will have 1 year from the date of notification to complete the pre-application review process. And then, of course, once they've completed the pre-application review process, if they were deemed eligible for further processing, they have an additional year to submit a temporary approval application record. So folks will have ample time, if they are selected through the lottery, to make the necessary business decisions to stand up a compliant location, be deemed eligible for further processing, and then of course submit the associated temporary approval application. Next slide, please. Our director is making it a point to get the verification process opened by the end of next month. She's made it clear that any other delays are non-negotiable. It will open by the end of next month. The reason why is the state has deadlines that impact social equity applicants and their ability to seek a provisional state license. And the state will stop accepting new applications for provisional licenses from social equity applicants, which the state refers to them as local equity applicants. We, of course, refer to them as social equity applicants on March 31st of 2023. So the director wants to ensure that we have the opportunity to administer the lottery, select social equity individual applicants through the lottery, and give those individual applicants an opportunity to complete their pre-application review and get their temporary approval application in before the state's March 31st, 2023 deadline. Next slide, please. I will now turn the presentation back over to the director. She mentioned future DCR events, and we've got a PowerPoint slide selected for that as well.
Thanks, Jason. I appreciate you taking time to make all of that information clear. Next slide, please. As mentioned in my welcome remarks, we have various events coming up. We're going to try and be as transparent and forthcoming about events and information as much as possible till the end of the year and into the future, if we can. Late April, we are going to be co-hosting a public health site evaluation webinar with the County of Public Health. Thursday, April 28th is going to be our usual Cannabis Regulation Commission meeting. Tuesday, May 3rd, Jason is going to be hosting our first of every single month now, a Q&A webinar lunch where he will answer your questions. Please make sure to sign up for that when you get the blast. And as Jason said earlier, we are going to be opening eligibility verification in late May. Yeah, again, it's non-negotiable. We want to make sure that social equity individual applicants who are verified have an opportunity to apply and get temporary approval before the state's deadline. So there are going to be a webinar in early May. Please look out for a communication in your inbox about how to RSVP for that. And we will also be doing likely another webinar before we open verification, date TBD, but that will be sometime in mid-May. So, and then in late May, we are going to open up verification. I want to thank everybody for coming today. It is 3:21, or sorry, 3:15 right now. We're going to take like a 3-minute break. We ask everybody, grab a glass of water, use the bathroom, come back, and we're going to do our Q&A. Jason, I don't know if I think you're unmuted there. If you're okay going a little bit longer than our stop date of a stop time of 3:30 today, I think the folks that have attended would appreciate that. We do see some questions coming in through the Q&A function of Zoom. Feel free to add your questions. We're going to try and get to them in real time. To those folks that remitted questions beforehand, we're going to get to your questions first. So we're going to take a little break for about 3 minutes. We hope that you come back and you join us and you get your questions answered. Thank you so much. We'll see you in about 3 minutes. Thanks, everybody. For those folks that stayed with us, we're going to move now into the Q&A portion of this event. We're likely going to go over our 3:30 stop time, so I hope that you'll continue to stay with us. Thanks so much. Olivia, are you ready to begin moderating the questions with Jason?
Yes.
Excellent. Let's proceed.
Okay, first question. What happens if I don't provide DCR with requested or required information, documents, or forms, or pay the required fees by my deadline?
Before I answer the question, I just want to let folks know that I don't have a hard stop until 4. So if we've got questions in the queue, I'm available to answer until 4 o'clock. For that question, DCR may deem an application or modification request abandoned if required information, documents, or forms are not timely provided, or if the fees are not paid on time. In most cases, applicants have 30 days to submit forms, documents, and information to DCR, as well as pay the fees. As I mentioned during the presentation, for temporary approval applications, we are going to be a little bit more lenient. So we'll give folks 2 opportunities to cure deficiencies. And then, of course, for modification requests, we'll give folks 1 opportunity to cure deficiencies, which is more than we currently do.
Next question. What is the phase 3 retail round 2 process?
Phase 3 retail round 2 is an opportunity for social equity individual applicants who are selected by lottery to submit temporary approval applications for a retail storefront license. Prior to the lottery, DCR will open up a registration period for folks that have been verified under the new social equity individual applicant eligibility verification criteria to register for the lottery. We'll be providing 45 days of technical assistance before we open that 30-day registration window. And we will be posting notice at least 15 days prior to the start of the phase 3 retail round 1 lottery, once we've collected all the registrations and verified that those individuals are in fact eligible to participate in the lottery. So more information on that will be forthcoming after we get through the eligibility verification process.
Who may apply in phase 3 retail round 2? And if we were qualified already as a social equity applicant, do we need to re-register again?
If you've already been verified, you do have to be verified through the revised process. Phase 3 retail round 2 is tied to the new eligibility criteria, and folks that want to participate in the lottery have to go through a re-verification to ensure that they meet the updated eligibility requirements. And then, of course, if they are verified, you will have to register to participate in the lottery. In order to participate in the lottery, you do have to be verified under the new criteria, and you must have a qualifying California cannabis arrest or conviction. Folks that do not have that qualifying arrest or conviction will not be eligible to participate in the lottery.
Do I need to secure a business location before I apply in phase 3 retail round 2?
Not to participate in the lottery. So folks will register an intent to participate in the lottery. We'll verify that they're eligible to participate, and we will conduct a lottery. The social and equity individual applicants selected through the lottery will have up to 1 year to submit a pre-application review record for a proposed business premises location anywhere in the city that has not reached undue concentration.
Okay, we have a few questions from Darwin B. The first one is, when will there be more grant money available?
Recently, we were awarded funds from the 2022 California Equity Grant. We're waiting to receive those funds. Once the funds are in hand, we will move forward with opening up additional grant programming. We did also receive a $22 million grant from the state to assist our licensees in navigating through the annual application process. Those grant funds will be available to existing licensees on a first come, first served basis. So the businesses with temporary approval will have their initial environmental analysis fees waived. And then for folks that navigate through the environmental analysis, provided funding is available, we'll be able to offer fee waivers for the annual license applications.
Great. Also from Darwin, where can I apply for the fee waiver or fee deferral?
There's not currently any fee waivers or fee deferrals available right now, but stay tuned, and Dr. Brown and her team will make more information available at a later date.
Last question from Darwin. When is the lottery, and isn't it for formerly incarcerated only?
Our goal is to conduct the lottery later this year. We have to do the verification process first, and that'll take approximately 6 months. The lottery isn't limited to people who were formerly incarcerated. However, it is limited to folks that are verified under the updated criteria. And as part of that verification, they will have to have a qualifying California cannabis arrest or conviction. Incarceration is not a requirement to meet the arrest criteria.
Question from Levon E. The latest submitted possible amendment changes said phase 3 retail round 1 applicants that had sensitive use issues in the top 200 would possibly get a second opportunity to submit to relocate. Is this in effect?
No, DCR recommended an amendment to the municipal code to allow this, but it was not approved by City Council.
A second question from Levon E. For a delivery license only, in which stage is the applicant supposed to submit for their state license?
Because our local process is decoupled from the state's licensing process, you could theoretically submit at any time, but the state will reach out to DCR, and then DCR has 60 days to notify them whether or not the applicant is not in compliance, local compliance is underway, or they're in compliance. In order for us to report local compliance underway, you will have to have had a temporary approval application be deemed filed and have received at least the status of local compliance underway.
From Benjamin L. Is there a license designation for a brand-only business?
Not at the city or DCR level.
From Jesse F. Can you please give us a date when the PCN applications will be accepted?
Unless the PCN process is further amended by policymakers, the PCN process will likely open later this year.
Okay, a question from Praveet S. The ordinance amendment clarifies issues around license abandonment. Phase 1 applications were submitted quite some time ago, and the new language around abandonment is making some of us nervous. Does the 1-year clock reset when a record in pre-license review has been approved for a location modification, or does the 1-year clock begin after the initial pre-licensing review occurs?
If a temporary approval application is deemed abandoned after January 1st of 2022, an applicant would have an opportunity to refile that application within 1 calendar year of the date DCR notified them of the abandonment. And the refiling consists initially of submitting that pre-application review record and then seeking the finding of eligible for further processing. So if the record was abandoned today you would have 1 year from today to submit your pre-application review record. If you submit early, you may have multiple opportunities to submit additional pre-application review records if earlier pre-application review records are deemed ineligible for further processing until you get to a status of eligible for processing. But you have a year. And then once you have the pre-application review record submitted, if that record is eligible for further processing, you have 1 year from that the date of the finding to submit your temporary approval application record. So kind of how the timelines kind of work is really going to be applicant dependent based on, you know, when and if they refile and they get through the pre-application review process, and when and if they get a finding of eligible for further processing through that pre-application review process.
A question from Marcus R. Is there a limit on cultivation licenses?
Yes. So individually, a person cannot hold more than 3 medium indoor cultivation licenses or any combination of cultivation licenses where the aggregate cultivation area would exceed 1.5 acres. So having more than the 3 medium indoor would exceed the 1.5 acre limit, which is why it's kind of 1 for 1. You know, a person with an aggregate ownership or profit sharing interest of 20% or more, and the person applying for the license may not hold that. So it's similar to the limitation of 3 retail storefront licenses in that way. And then of course, citywide, there is a limit on the number of temporary approval applications DCR may process until a community plan area is subject to a finding of undue concentration. Once a community plan area has reached undue concentration, the cultivation activity may be pursued in the future through the PCN process.
From Nick S. Will social equity applicants who have been arrested for cannabis be able to obtain a cultivation license ever? For those who don't get awarded a license for retail or cultivation, will they have a chance in the future to get a license?
So, you know, the department's going to be opening a new verification window. Separate and apart from that, DCR hopes to open up the cultivation license type in the future. And if a community plan area has reached undue concentration for cultivation, applying for a public convenience or necessity finding to allow DCR to process a cultivation application may also be available in the future. You know, the goal is to reopen that process, but we do not have a firm date of when that will happen.
From Hannah A. If you withdraw or abandon a license and reapply, would you be guaranteed a license as long as paperwork is submitted correctly? Basically, would a social equity applicant not lose its top 200 spot in retail round 1?
I'm going to go ahead and kind of restate the question. So if you received a license, you're not going to get a finding of abandonment. Either you timely renew that license or you allow the license to expire. But those two things are separate and apart from the abandonment process. Abandonment relates to pending records, whether it's a temporary approval application record, a modification request, the pre-application review record. If you don't meet the filing requirements within the designated time, those records may be deemed abandoned. Only temporary approval applications deemed abandoned after January 1st of 2022 are eligible for refiling. So if you are one of the 200 phase 3 retail round 1 applicants and you have not received a license and your temporary approval application record is deemed abandoned, then you will be afforded the opportunity to refile for up to 1 year from the date that the record is deemed abandoned. because you were part of phase 3 retail round 1, you will have the opportunity to refile as a phase 3 retail round 1 applicant. And as long as you meet the refiling requirements, DCR will still have the ability to reconsider your application, because the application itself is not subject to a finding of undue concentration, and your application doesn't count toward the undue concentration limits. So regardless of what happens in phase 3 retail round 2, those applicants don't impact you, and your refiled application doesn't impact them. But there is no guarantee anybody will receive a license. You have to meet the requirements to be issued temporary approval. And then of course, you're going to have to meet the environmental review requirements and the annual application requirements and go through the necessary public hearings to be eligible to receive an annual license. No guarantees.
From Latrina R, when will the social equity application / licensing process be open for new applicants?
Verified social equity individual applicants are able to submit social equity applications right now for manufacturing, distribution, non-storefront delivery. DCR will be doing another round of verifications to identify social equity individual applicants that may be eligible to participate in the phase 3 retail round 2 lottery. I recommend that you tune in and you subscribe to newsletters and stuff so you can participate in future webinars to get more information about the upcoming verification process, as well as what it will take to register for the phase 3 retail round 2 lottery. If you're already a verified applicant and you plan to pursue non-volatile manufacturing, distribution, or non-storefront delivery, I would recommend reaching out to Dr. Brown's social equity team to see what resources are available to you to assist you in pursuing those opportunities.
From Ramin, do we still need form LIC-4001-mod?
Yes. The general modification cover sheet is still a requirement on our process. We've got some modification forms that are unique to different modification types, but the cover sheet is really a catch-all and a single document that kind of indicates what types of modifications you're trying to pursue. As we look to further streamline and update our process, we may look to convert that form to a selection form within the DCR licensing portal, so it doesn't have to be submitted, but currently you do have to submit the form.
From Norma C, are neighborhood councils still involved in the application process? If so, have there been any changes in regards to their involvement?
There have not been any recent changes regarding their involvement.
Sorry, go ahead.
No, there's been no recent changes.
From Mary, what is the difference between an annual and provisional license?
This is terminology used by the state. A provisional license is effectively a temporary license. It means that you have met certain criteria. However, you have not met all of the criteria necessary to issue an annual license. Environmental review is one of the most contentious things that happen in the state of California. And DCR and the state have argued for several years over who was going to be the lead agency in regards to commercial cannabis regulation. The city, of course, always looked to the state agency because their licenses are required to operate lawfully within our state to be the lead agency. And then DCR looked to them to complete that analysis and issue an annual license before we would consider issuing an annual license. Based on changes the state made last year, They kind of flipped the script on us, and now we will be the lead agency, and we will be responsible for conducting that analysis and issuing local annual licenses before a business may be able to submit a complete annual state license. The provisional or the temporary licenses, temporary approval as DCR calls it, were intended to assist businesses in getting up and running while they navigate through the two different annual licensing processes.
From Demetrius, when will the lottery be available?
Our goal is to open up the lottery later this year. We don't have a firm date. Our first goal is to open up the verification window and then administer it. That process will take approximately 6 months, and then and only then can we have a discussion about when we could administer the lottery. So stay tuned. We'll be doing additional updates and webinars and outreach surrounding the verification process, and then of course, phase 3 retail round 2.
From Amy and Andre G. If we were qualified already as a social equity applicant, do we need to re-register again?
If you would like to register to participate in the phase 3 retail round 2 lottery, yes, you will need to get re-verified under the new criteria. If you've already been verified and you're seeking to apply for non-storefront delivery, non-volatile manufacturing, distribution, you may already submit those types of pre-application review records and or temporary approval application records if you've already gone through the pre-application review.
From Jeremiah W. Is there any reason to go through the verification process again if you have now been disqualified due to not having been convicted of a cannabis-related offense?
You can submit for verification even if you don't have a qualifying arrest or a conviction. You can still qualify based on low income status and then residency in a disproportionately impacted area. Although you won't be able to participate in the phase 3 retail round 2 lottery, you may pursue other social equity license types, such as non-storefront delivery, non-volatile manufacturing, or distribution.
From Latrina R. Will there be a webinar for applying for a cannabis license for dummies?
Dr. Brown would never allow us to call it that. But she and the vendors that were selected are doing, various outreach to walk people through what the application and the licensing requirements are. If you are a verified social equity individual applicant, there is a ton of material available through the learning management system. And I know Dr. Brown and her vendors are going to be doing upcoming Q&A sessions where folks have an opportunity to drop in and ask questions, and they'll be answered in real time. So there are a lot of resources there.
From Young K, must you have a location to start the application process, or can you add a location during the application process?
In order to go through pre-application review, which is a prerequisite to submit a temporary approval application, you must have a proposed business premises location. You do not have to have site control of the location, which means that you don't have to have purchased the location or executed a lease. You just need to submit a landowner attestation. In order to register to participate in the phase 3 retail round 2 lottery, you do not have to have a location.
From Lawrence and Molina, who had a similar question. If someone isn't currently or hasn't been a California resident in the last 15 years, but had a conviction in California in 1978, would they still qualify?
For the California cannabis related arrest or conviction, a conviction in 1978 would check the box for that requirement. In order to get verified, you would still need to qualify as being low income or having a cumulative residency in a disproportionately impacted area for at least 10 years.
From Kareen, when can PCN applicants reapply?
At the moment, the PCN process is closed. DCR is working with the city council, and we hope to reopen the process later this year, provided that the city council and the mayor do not opt to make any changes to the program.
From Eric S. As a current social equity program tier 1 and tier 2 qualified applicant, can I apply for another type 9 license at the moment? Or do I have to wait and requalify as a social equity applicant again in May?
If you've already been verified, you may apply for a type 9 license, which is the non-storefront delivery license type.
Another question from Eric S. Do the new changes apply to current applications or only to new applications moving forward?
I don't think I have enough information to answer the question, but process changes in terms of the timelines DCR has to adhere to are in effect when the ordinance becomes in effect. It sets concrete timelines for, when DCR has to perform a given task. That will apply to existing records and records that get submitted in the future. In terms of the types of applications people can submit or whether or not they have the ability to refile, the only thing that council grandfathered in or made retroactive to an earlier date is the refiling process, so that if a temporary approval application record was deemed abandoned after January 1st of 2022, that applicant would have up to 1 year from the date they were notified to refile.
From Alfred, if I want to move my cultivation facility to a new location because the building I am in isn't up to code or I can't find a location in our planned area, what are my options? Can I request special permission from DCR or the Cannabis Commission to move to a different community plan area?
So the answer to the second question is no. DCR and or the Cannabis Regulation Commission do not have discretion to allow for folks to move an application to a different community plan area. If you have a license, then you can move to a new location within the same community plan area. If you have a pending application, the business premises address listed on the application cannot be amended. So on that type of record, the only path forward would be for it to be deemed abandoned if you could not get a license at the location, and then to utilize the refiling process to look for a compliant location and then refile through the pre-application review process once you've found what you think is a compliant location within that same community plan area.
Also from Alfred, how many retail licenses will be issued in phase 3 retail round 2?
The total number will be determined at a later date. It's all going to be based on the total retail storefront license capacity at that time. As we seek to hold ourselves and our round 1 applicants accountable for meeting certain processing milestones, records may be deemed abandoned, which will create additional capacity for round 2. Of course, folks that have their records deemed abandoned still get the benefit of refiling within 1 year, and they aren't subject to a finding of undue concentration, and their refiled application doesn't count toward the undue concentration calculation. Therefore, it won't impact our ability to administer phase 3 retail round 2. But there are at least 100 retail storefront application spots that would be available within phase 3 retail round 2, and it could be higher.
The last question from Kevin. Can a phase 3 round 1 social equity person from tier 1 that is currently a 51% owner of one license join and become an owner of a second phase 3 round 1 license as a 51% owner?
No. If somebody was granted the opportunity to be the qualifying social equity individual applicant on a phase 3 retail round 1 record, that person may not be the qualifying social equity individual applicant on a phase 3 retail round 2 lottery registration, which would be the prerequisite to qualify to submit a phase 3 retail round 2 temporary approval application. However, the person could be a owner not with the qualifying interest of a phase 3 retail round 2 application when it gets submitted, and or you would still have an opportunity to consider purchasing equity in that business after a license is issued, provided it meets the requirements. You know, the qualifying social equity individual applicant is limited during the temporary approval application phase. However, once temporary approval is issued, it's a form of licensure, and then DCR can consider, you know, modification requests that would remove the qualifying social equity individual applicant. So your question comes down to timing. On the front end, you would not be able to double dip and be a first in time round 1 owner and a first in time round 2 owner, but you could look to pursue a license after a license was issued in phase 3 retail round 2. Under current law, everything is always subject to future policy changes.
Okay, thank you. That was our last question.
Hi, everybody. Thanks for joining us today. This is Michelle again. I just want to say thanks, everybody, for sticking around until 4 o'clock to get their answers to their questions. Jason will be providing his time on May 3rd to do essentially a Q&A. We may not see each other all before 420, so the DCR would like to wish everybody a happy 420. We hope that everybody celebrates responsibility or responsible. Please look out for an email from us signaling where to legally purchase cannabis and how to legally engage. To that end, thank you so much, and we hope you have a wonderful day.